Good morning, ladies and gentlemen. Thank you very much for give me time to deliver my presentation of my research. The title is Spreading Information Online that Contain Hate or Hostility and Ethnicity, Religion, Race, and Intergroup Relation, or SARA, Issues in Criminal Law. And thank you very much for the committee of the fourth ICCOMSET International Conference on the Computer Science, Engineering, and Technology. My research organized by me and my colleagues Batara Muli Hasibuan, Alfia from Business Law Program, Faculty of Humanities, Binus University. Okay, this is the introduction. My background of research according to the case of SARA, ethnic, religion, race, intergroup, from the ICGR. ICGR is Indonesia Criminal Justice Reform, is a national NGO. According to the ICGR, there are three forms of cases of SARA. Morality, there is 242. This is related with the Article 27, paragraph 1. The second is insult and defamation. There is 268 cases related with the Article 27, paragraph 3, Law number 19/2016, Junto Law number 11/2008. And the last is hate speech. There are 217 cases. This is related with the Article 28, Law number 19/2016, Junto Law number 11/2008. And the second figure is from SEPNET. SEPNET also is a national NGO working for the ITE Law. According to the SEPNET, in the 2020, increased cases of SARA. There is 106 suspects were recorded by the NGO. The article on defamation and hate speech of the ITE Law were the most widely used as a basis for these cases. And the same data from SEPNET states that 38% of the reporting violation of the ITE Law are public officials, including regional heads of agencies, ministers, and security posts. And also, the majority of those reported are ordinary citizens, journalists, activists, lecturers, teachers, artists, and also cultural observers and writers. According to the background, the research problem is the first, the potential to penalize people who voice their opinion on social media. No legal interpretation of concept SARA according to the law number 19/2016 and 11/2008. And then the interpretation of article, especially 28 paragraph 2 of the ITE Law, are multi-interpretation. So every law enforcers have different perception of the element article 28 paragraph 2. So in this research, we also discuss some cases, but for my presentation, I only deliver one case. Result and discussion. The first interpretation is a method of legal discovery that provide a clear explanation of the text. The second, the method of interpretation is mean or tool to find out the meaning of the law. So my research is how to make a limitation the concept of SARA, because in the ITE law there are a lot of interpretation but no clear definition. So according to the doctrine of interpretation, there are 6 methods of interpretation. The first, grammatical; the second, historical; the third, systematic; the fourth, theological; the fifth, comparative interpretation or comparative law; and the sixth, futuristic; and the seventh, this is a multi-interpretation, not only from the grammatical, historical, but how to combine the method of the interpretation. So I will explain what's the meaning grammatical interpretation. Grammatical interpretation, according to this interpretation, is according or on basis everyday language, which means interpretation on the basis of everyday language used by relevant community. This interpretation work in the time of finding the true meaning or a formulation of legal norms or part or element thereof. When we interpreting the term of hates and SARA, the grammatical interpretation refers to the legal dictionary, the Great Dictionary of Indonesia Language or KBBI, and also Black Law Dictionary. Hate and SARA or rasa kebencian and SARA in Indonesia, the words feeling or rasa, according to the Great Dictionary of Indonesia Language, is sensory response to nerve stimulation such as sweet, bitter, sour to the scent, hot, cold, fine to the sense of taste. This is the meaning of hate and SARA according to the grammatical interpretation. The second, historical interpretation. Interpretation by examining history. This interpretation look at the intent of the provision of the law as seen by the legislator at the time of their formation or from the thoughts that underlie the will of the legislator listed in the text of the law. So historical interpretation will look from the history when the law adopted by the parliament and also by the government. There are no articles that regulate hate speech after the draft law was made and then sent to the House of Representatives of Indonesia or DPR. New rules regarding hate speech were added because of the interest of legislators to protect various groups. The hate speech article in the ITE Law refers to the Article 156 of the Criminal Code, or which prohibit the hatred of races and entities of Indonesia population group. And the second is a systematic interpretation. It means synonymous with interpreting statutory regulation by linking them with other legal or statutory regulation or with the entire legal system, so that they may not deviate or leave the statutory system or legal system. The ITE law is connected to the Article 156 or of the Criminal Code, Article 157 of the Criminal Code, Article 310 of the Criminal Code, Article 311 of the Criminal Code, and Article 16 of the Law Number 40, 2008, concerning the elimination of racial and ethnic discrimination. Such article contain criminal penalties for a person who expresses formulation, hatred, and insult to certain groups. So the last problem we will discuss in my paper about the analysis of court decision. I only take one court decision for my research. This case is the hate speech crime by one of the journalists from the Kumpayan.com, who was charged with violating Article 28, paragraph 2 of the ITE Law. When viewed from the legal perspective, the subject is journalists. Journalists have their own legal umbrella, and journalists should be charged under Undang-Undang Pers or Pers Law, namely Law Number 40 of 1999. The first law is less specialist of the ITE Law. In this decision, the defendant has the right to disseminate information because it is the duty of the press to provide information to the public. However, disseminating information containing element of the SARA, yeah. So the element of the SARA must be analyzed, whether this is related with the ITE Law or this is the right of the press to publish the reality or the fact from the community. Articles in the press law are not appropriate when resolving press issue to the court because the press council has provided the press council, which can help provide the right of relief, replay, and the right of the correction. So if someone feel not satisfied with the pairs, so they can complain to the pairs and also report to the council. Criminal provision in the first law are regulated in the Article 18 of the first law. The first cannot be punished because it refers to the provision of Article 8 of the first law, which provide basic, comprehensive, and professional protection for the journalist profession. As long as journalists carry out their duties under the first law, the Journalistic Code of Ethics and Derivative Regulation, journalists cannot be punished. If the press makes the mistake that is not regulated in the relevant regulation, it will be subject to the fine through a lawsuit, not the criminal procedure. This is my conclusion. Article 28, paragraph 2 of the ITE Law can be interpreted with the various interpretations. However, in the decision was reviewed by the panel of judges using grammatical interpretation by the prosecutor, using grammatical interpretation, and by lawyers using grammatical, systematic, and theological interpretation. Due to the wide variety of the interpretation in criminal law, law enforcers can be explore the type of interpretation that are in the accordance with the context of the case and the context of the law relating to the case. Judges need to use health interpretation that consider aspects of the mitigate the sentence for the defendant. Thank you very much for your attention, and I look forward your question, and we will discuss about the problem of my research, and also the next revision of my paper. Thank you very much.